Eisenbaum. I'm your co-presenter for this webinar. Welcome to the Gray-Duffy webinar on trivial or consequences regarding sidewalk liability issues. My partner, Barry Brown, is also the co-presenter on this webinar. Say hi, Barry.
Good morning, all.
There you go. Now we have a picture of both of us. Essentially, this webinar today is going to deal with two main issues regarding sidewalk or pathway liability issues. And the first is liability shifting ordinances created by city entities. Barry's going to be discussing that first. And then I will be discussing issues pertaining to the trivial defect doctrine and its impact on liability issues, and in particular with respect to lawsuits and litigation by members of the public that have been injured as a result of defects in sidewalks or other pathways. So Barry, I'll turn it over to you, and go ahead and get started.
Okay, thanks, Mike. Good morning, all. The first slide we have here is sort of the typical lawsuit. We have an injured party down at the bottom, and they have decided to sue or make claims on both the landowner and the municipality in which the incident occurred. There's also the arrow going between the landowner and the municipality, indicating that in all likelihood the two parties will file indemnity actions against each other for the injury to the plaintiff. Next slide, Mike. Liability between municipalities and landowners for injuries sustained by pedestrians due to defective sidewalk conditions have been the subject to lawsuits and statutory enactments for years. In California, municipalities generally own the sidewalks adjacent to private property owners' land, but state law provides that landowners are responsible for maintaining the sidewalks fronting on their property in a safe and usable manner. And that responsibility started out with Streets and Highways Code Section 5610, which you see on the slide. If you read through that code section, one could certainly think that, well, that means that the landowner has liability to any pedestrians who may fall because of defective conditions that haven't been repaired by the property owner. That was the subject of a lawsuit. Mike, next slide, please. Next one. The first early case came on in Williams versus Foster, and that was a lawsuit that was brought by a Dennis Wilson who was injured when he fell on the sidewalk in front of property owned by Mr. Foster, Calvin Foster. Mr. Williams sued both Foster and the city of San Jose for his injuries. Apparently the surface of the sidewalk had been made uneven by roots of a tree planted in the parkway in front of Mr. Foster's property. The tree was planted by the city of San Jose. The court found that the city of San Jose had responsibility, but Mr. Foster did not. And the rationale for that was that Street and Highways Code Section 5610 did not provide clear and unambiguous language that liability for the injury would be the responsibility of the property owner. And without some type of specific ordinance that would be clear and unambiguous, the Street and Highways Code Section 5610 did not provide that liability to the homeowner. As a result of the Williams versus Foster's case, the city of San Jose enacted City Ordinance 14.16.2205 And Mike, for a moment, if you go to the next slide, we can show that code section or that ordinance.
There we go.
And this ordinance was specifically in response to the Williams versus Foster lawsuit and the court's finding. This ordinance was tested in a case in 2004 entitled Gonzalez versus the City of San Jose. Go back to, yeah, there we go, thank you. In the City of San Jose, the primary issue before the state court at that time was whether or not this ordinance was preempted by state law and whether it was constitutional or not. In its holding, the Gonzalez court noted that the cities are empowered under the California Constitution to enact ordinances and regulations that are deemed necessary to protect the public health, safety, and welfare, and the City of San Jose's ordinance was a permissible exercise of that power. The court noted that without such an ordinance, the landowners would have no incentive to maintain adjacent sidewalks in a safe manner. The court did emphasize, though, that the ordinance did not absolve the city of liability for dangerous conditions on city-owned sidewalks, as that would be contrary to state law. So essentially what the ordinance shifting and liability shifting ordinance established was a way for the city to bring in the homeowner or the property owner as being responsible for injuries to pedestrians, for sidewalk injuries. Now, since San Jose was one of the earliest municipalities to enact such an ordinance. And since the City of San Jose did that and the Gonzalez case came down affirming that the cities and municipalities had the ability to enact such ordinances, many cities have taken up that issue and looked at it. Not all have enacted ordinances. And in my research, I've come across a number of opinions by various city attorneys. City Attorney of Oakland, City Attorney of San Jose have addressed these issues to their city councils and recommended essentially that ordinance be established that would shift liability over to property owners, or at least bring the property owners into the liability picture. San Jose obviously has an ordinance, Sacramento has an ordinance, San Francisco has an ordinance, but other cities, large cities, San Diego, Los Angeles, and Oakland, although they consider the issues, don't have such ordinances. And the apparent rationale is, for the cities that don't have the ordinances, is that the cities want to have more continuity in how they deal with sidewalk repairs. There's obviously been a lot of opposition from various property owner entities that have opposed any such ordinances. And so for various public policy reasons, the cities and entities and municipalities have not formally enacted such ordinances.
Hey, Barry, do you have any suggestions as to how to find out if a particular city has an ordinance yet or if they're considering one?
Yeah, the two ways that I've looked at it on cases I've had and just in looking at the issue, you can obviously go directly to the municipality's ordinances and try to wind your way through the various ordinances. You can also do a Google search, which I've done on occasion, just naming the city and then either city ordinances or liability, sidewalk liability shifting ordinances, and oftentimes that will lead you to the information. With the ordinances being sometimes as lengthy as they are, sometimes it's difficult to locate them, but those are the two ways I've gone about it, and with pretty good luck eventually.
Okay, it's a good suggestion.
Yeah. So go to the next slide, Mike.
Yeah.
So in analyzing a case you have, and whether or not you've got the property owner or the city for that matter, the first thing you need to look at is the existence of the ordinance, whether an ordinance does exist. If it doesn't, you wind up going back to the common law, which essentially is that the property owner does not have any liability for pedestrian injuries for defective sidewalk conditions. Even when there is an ordinance, you need to look specifically at the language of the ordinance to determine the nature and scope of the ordinance. Again, going back to common law before the ordinances were prepared, if a pedestrian falls on a condition that is created by the landowner, then the landowner does have responsibility with or without the existence of an ordinance. In situations where you have an ordinance, the landowner can be responsible even when the defective condition is created by the city or the third party. So it is important to look at whether or not there is an ordinance in existence in your municipality, the language of that ordinance, the nature and the scope of it, and then, of course, the specific cause of the sidewalk condition. The last issue there, the cause of the sidewalk condition, is going to be important to decide which of the entities, whether it's the property owner or the municipality, has exposure and how much exposure they have.
And it's the specific ordinances at issue that you have to look at, which should hopefully give you guidance on that as to who the city is considering responsible for a particular cause of a defect or a condition.
Well, actually, not really. The code sections I've seen, and specifically the San Jose code section, which we've listed, and also there's a Sacramento ordinance, which is we haven't got on our list, but it's 12.32.040 of the Sacramento City Code, and it's a pretty basic ordinance in general. The Sacramento Code simply says each owner required by Section 12.32.020 to repair a defective sidewalk shall owe a duty to members of the public to keep and maintain the sidewalk area in a non-defective condition. And they say if they don't, then they've got liability. So the ordinances themselves are fairly general and just establish the duty on the part of the property owner, which is a duty they wouldn't have without that statute or the ordinance. So going to who actually is responsible, ultimately, if there is an ordinance, again, that becomes an issue of what the specific cause of the sidewalk condition is, who created it, and who had notice of it. If the cause of the defect in the sidewalk, for example, is upheaval of the sidewalk by roots of a tree, and those trees were planted by the city will still have at least the lion's share of responsibility for that condition, even with an ordinance in place. And the same on the other side, if the cause of the upheaval of the sidewalk is created by trees that were planted or maintained by the property owner, then the property owner is going to bear the larger portion of responsibility for the defective condition and the injuries to the pedestrian.
And does one other question while we're on this topic, does, even if there's no ordinance, it's depending on what's the cause also, is it generally considered that it's going to be the city's responsibility if there's no ordinance, or is it still going to be shared with the property owner depending on the cause?
Well, depending on the cause, it may be shared by the property owner to some extent, but without the ordinance, you go back to the common law, and the common law essentially says that the property owner is not responsible for the conditions of the sidewalk, and that is unless they have created the condition.
I'm gonna flash back here to the actual streets and highways code. What's the exact, since this is a California code, correct? So it's across all of California.
Correct.
So what's the impact of this code section?
Well, the impact of this code section generally is a more of a cost of repair issue. This deals with the state and the city's ability to assess the homeowner for the cost of repairing the sidewalk if the city does that. Again, this was the issue raised in the Williams versus Foster case, where the city was attempting to use that code section as a basis for imposing liability on the, in this case again, the city of San Jose, for the injuries sustained as a result of the defective sidewalk. And the court said, no, that's not what 5610 says. It does not impose liability.
To third parties.
To third parties. The 5610 really only deals with the issue of reimbursing the city for expenses in repairing sidewalk defects.
Oh. So anytime the city repairs a sidewalk, they could bill the homeowner under 5610 of the Streets and Highways Code?
Under 5610, yes, but there's again, there's a lot of ordinances, sort of different from the issue of liability, but there's a lot of ordinances dealing with how various cities handle the reimbursement by the property owner of expenses incurred by the city. There's a number of programs throughout the state where the city and the property owner will share 50-50 on any repairs. And I think most cities have specific programs and ordinances dealing with how reimbursement is going to take place, if the property owner does it as opposed to the city doing it, what type of forms need to be filled out to get reimbursement from the city if the homeowner does it, or the property owner does it. But that really doesn't have to do with the liability to third parties for injuries sustained on the sidewalks.
Gotcha. Okay. Anything else on your liability shifting ordinances topic?
No, I think that pretty well covers it.
Okay. We'll go ahead and move on to trivial defect doctrine. Oh, and I might add, for everyone listening, there should be a question box on your screen that you can type in questions as we go along. We have saved some time at the end as well to answer questions. We may be able to answer them as we go through, but feel free to ask any questions and tell us what's on your mind if there's a particular issue you'd like us to address as we go through this. Looking at the trivial defect doctrine, that's what it's been called now by the courts. On your screen is basically the definition of it as developed by the case law. We're talking about whether or not a condition is dangerous or not, whether it creates a likelihood of a substantial risk of injury is another way to describe it. Here we've said a condition is not considered dangerous if the risk created by the condition is of such a minor, trivial, or insignificant nature in view of all the circumstances that no person would conclude the condition creates a substantial risk of injury when a property is used with due care. So typical of appellate courts, they're going to look at all the circumstances surrounding a particular situation or a condition, and they've given us a guideline and several guidelines that we'll go through in a minute as to what might be considered a trivial defect, because if it is a trivial defect, then it's not reasonably expected to cause accidents, i.e. no substantial risk of injury, and therefore when there's a trivial defect, if it's determined to be a trivial defect, there's essentially no liability by either the property owner or the city entity. Of course, that doesn't stop them from getting sued, so this becomes a method by which either a city or private landowner can extricate themselves from the lawsuit potentially. When we're talking about the trivial defect doctrine, we're mostly talking about sidewalks or walkways. You know, in residential neighborhoods, you've got sidewalks adjacent to the roads, and we've all seen where the trees that are typically planted in the park strip between the sidewalk and the road cause the sidewalks to buckle, and sometimes the city comes out and repairs those. Sometimes they just kind of asphalt over the crack and create a little ramp. Not always the best methods of repairs, but especially here in Los Angeles, where the city has a program, but it takes them a while. I think it's determined to be a 30-year program to repair the sidewalks. So a lot of people can fall in the next 30 years on these things. But theoretically, the trivial defect doctrine can apply to any type of pathway, even dirt, or other surfaces such as parking lots where pedestrians are known to walk. I've had a number of cases where people trip in parking lots over cracked asphalt. And the same principles would apply as to whether or not a particular crack or defect in the parking lot or the walkway or the pathway is sufficient to where it presents a substantial likelihood or a significant likelihood to cause injury, and therefore it should probably be repaired, or the landowner or the city could be on the hook for any injuries that it causes. This goes to the essence of the trivial defect doctrine. I used to think of it as more of an affirmative defense, but as I got more into the case law, I discovered it's not really an affirmative defense. It is an aspect of the landowner's duty which a plaintiff must plead and prove. So it goes directly to the issue of duty. If it's a trivial defect, there is no duty to repair it. The converse of that is if it's something more than a trivial defect, then arguably there was a duty to repair it, and then you get into issues as to notice to the property owner and so forth, how long the crack may have existed, to provide notice to the landowner that it should be repaired. Fortunately, the trivial defect doctrine, because it's an element of the plaintiff's pleading and proof in a negligence case, the issue of duty, it allows a court to determine whether the defect is trivial as a matter of law rather than submitting the question to a jury. Again, the law imposes no duty on a landowner, including a public entity, to repair trivial defects, or as the courts say, to maintain the property in an absolutely perfect condition. That would be an impossible burden, and the courts have recognized that. Essentially, some defects are bound to exist even in the exercise of reasonable care in the maintenance of the property, and would not reasonably be expected to cause accidents. Those are some quotes from some of the cases. So when you look at a trivial defect issue, there's a number of factors to consider. Far and away, under the appellate decisions that we've looked at, here in California at least, and I think California provides sort of an overall guideline across the country as well. Size is certainly the most important issue you're going to be looking at. Size does matter. And when you talk about size, that would include, most significantly, the depth or vertical displacement of the defect. Basically, the height of the separation between parts of a walkway or a sidewalk. But it would also include the length or the width of the defect as well. If we're talking about a crack, the wider it is, if your foot can get caught in it, or, the heel of a shoe, particularly a woman's shoe that may be a smaller heel or a pointed heel, can get caught in it, causing a person to fall as a result. The most significant issue of size is more of the vertical height, and under the case law decisions, I'll call it the 1-inch rule. Seems to be a pretty good cutoff for when courts are finding things to be trivial or not. Some decisions have gone above 1 inch, But again, it's going to depend on all the factors. So if you've got a little crack in your sidewalk and a 1/2 inch offset, you probably don't need to repair it in the absence of other aggravating factors surrounding the defect. Well, what would those other aggravating factors be? There's a few of them that courts have looked at, quite a few of them actually. You can see on your screen I've listed most of them. Whether or not there's been prior accidents or injuries. Has this defect caused somebody else to fall and get hurt? Almost kind of the one free trip and fall rule if it's otherwise a trivial defect. What was a trivial defect can become not so trivial if it's already caused somebody to fall and get injured. So whether or not there's been prior accidents or injuries from that same defect is something the courts will look at. So for those property owners out there or people defending property owners, once you've had a fall on a condition, you probably want to go ahead and repair it. And if you don't, you've just added a factor that the court's going to look at to help them find liability against the landowner, or the city for that matter, if it's a city sidewalk. Another factor is whether or not it's irregular or a jagged-shaped defect. If it's just you can see in the slide you've got those expansion joints in the sidewalks, and sometimes like in California where we have seismic activity, the sidewalks will be a series of panels that are not interconnected. And so sometimes one panel will rise slightly above the other at the joint and create a trip hazard if it gets big enough. And certainly if a sidewalk gets cracked and it's jagged, it presents a little bit more of a problem because it may be, in the court's minds, more likely to cause an injury because it's not just a clean break or separation in the sidewalk. Also, if there's broken pieces of sidewalk, that's part of it, and they may be loose, that can cause people to stumble or roll their ankle. That's going to be looked at if that's an issue. Also, any debris that might be part of the defect or obscuring the defect. So if you've got a bunch of leaves or branches over a hole in the sidewalk and it's basically a trap or an accident waiting to happen because there's a substantial groove or crack or hole or missing part of the concrete and somebody can't see it and steps on the debris and falls into the crack and breaks their ankle, that could be a problem, even though the separation may not be otherwise sufficient enough in the absence of having debris covering it to be, a repairable defect. Also, lighting conditions may be looked at. A lot of people seem to trip and fall at night over just about anything. Especially for private landowners where you've got internal walkways in apartment buildings or commercial areas, retail buildings and so forth, which are usually pretty well lit. But if you have lights that are out and they've been out for a sufficient period of time and not repaired and somebody falls, that can be a problem. Courts are going to look at that, and that's going to be something the plaintiff's going to point to and say, well, the light was out. Then you got to ask, well, how long was the light out? Maybe it just went out 10 seconds before the person came along and tripped. You get into notice issues at that point. So another factor that I think is probably on the higher end of the spectrum of being important is the plaintiff's knowledge of the area. If this is an area that plaintiff has walked across, for example, in their own apartment complex, the pathway leading to the pool, for example, and there's a little crack in the walkway, and they've traversed it many times successfully, never complained about it, and nobody's ever complained about it. And then one day they walk along and they trip over it, maybe at night. Is it still a trivial defect because it went from day to night? Hard to say. But to give you an example, as a matter of fact, yesterday I got a summary judgment motion granted on the trivial defect doctrine. And it was that very issue. It was a crack, actually a vertical displacement between two panels or two sections of a walkway in an apartment complex that the plaintiff had actually gone out and measured about a week after her accident. And according to the tape measure, which you had to zoom in on, thank goodness for high-resolution digital photos these days, so you could zoom in on it and you could actually see the measurement was roughly 3/8 of an inch. It just wasn't that big of a defect. From some angles, without a tape measure, it looked bad. From other angles, it looked like you couldn't even tell it was there. But with the plaintiff's own photographs and her own testimony that she measured it, and that was the measurement, she actually lost her case on a motion for summary judgment. So this does work to get out of lawsuits. It also gives us a lot of guidance in deciding when to repair a walkway as landowners, or if you're defending landowners, you can say, you know, it's bad enough, you should have repaired it. Now that this person fell and was injured, you're kind of stuck with liability. And once one person's fallen there, prudence dictates that that condition should be repaired. And you want to repair it promptly, or at least until you can repair it, put some sort of warning down, any type of cone, anything like that to show, to at least alert people to it, especially if it's not that big of a crack, because it's hard to see. And we can all, you know, we've all done it. We've all caught the edge of our shoe or our foot on these little cracks, little separations, and almost fallen, or we've seen people fall, or had people we know that have fallen. It can happen, and the courts have really drawn the line at this 1-inch mark. I think if you're dealing with a crack that's been measured and it's less than an inch, and there's no other aggravating factors, you have a pretty good shot at a defense. I call it a defense, but basically disproving or defeating the plaintiff's claim and defeating any liability, again, because you had no duty to repair that if that was the first time somebody fell over it. So with that, you know, I think that's the end of my presentation. There's time for questions if anybody has any. We were expecting this to last about 30 to 40 minutes. We're at about 36 minutes. If anybody has any questions, we're going to be on for another few minutes. Feel free to type in your questions, and we'll be happy to answer anything that you have. Barry, how about you? Do you have any questions about the trivial defect doctrine?
No, but I was just going to actually add to that. If after the webinar is completed, if you're sitting back in your office and all of a sudden something strikes you, both of our emails addresses are on the slide that's in front of you right now, so you can certainly send us an email or give us a call, and we'd be more than happy to talk with you about this.
Okay. All right. I don't see any questions popping up. Let me just look here if anybody's put it in the chat room. Nope, none there either. Okay, absent any questions, this concludes the Gray Duffy webinar on trivial or consequences. I appreciate everybody listening in, or we appreciate everybody listening in, I should say, and I hope you were able to get some useful information out of this. Thank you very much.
Thank you.